Namaste and welcome to a brief overview of share capital. In this part B video, we will be covering securities premium account, shares issued at a discount, further issue of capital, sweat equity and bonus shares. Please refer part A video for capital and rights and part C video for employee stock option and global deposit receipt and change in capital. Having covered capital and rights in our earlier video, here we will be dealing with premium and discount. Section 52 deals with share premium account and section 53 deals with shares issued at a discount. We will be taking up the share premium account wherein the company will be making use of the share premium received on issue of shares for authorized purposes. Application of premium received on issue of shares. Section 52 talks about this, where a company issues shares at a premium. The amount of premium as received shall be transferred to a securities premium account or share premium account. This is so far as the nomenclature of the account where the share premium is parked in the financial accounts. Then, where we can use it? The section says you can use share premium account for specific purposes. You can use it for issuing fully paid bonus shares. If you have got in your balance sheet preliminary expenses carried forward, you can use this to write off and set off one against the other. If there are expenses which you have incurred in issuing shares and debentures, those expenses can be set off against the share premium account. And you might have redeemable preference shares which you will be redeeming. When you redeem a preference shares, you might be paying premium. You can use this premium to pay the premium on redemption. And share premium can also be used to purchase own shares, which we call as buyback. Buyback of shares under section 68. These and share premium could be used for these purposes and these purposes only. 5 purposes: issue bonus shares, write off preliminary expenses, write off issue expenses of debentures and shares, or use it for premium of redeemable preference shares, or you can use it to buy shares of one's own company, which is called buyback. In addition to that, if you don't use it for these purposes and use it somewhere else, then it amounts to reduction of capital. Now, you will ask us as to what is great about it. Reduction of share capital is not permitted in the normal course. It is a deviation. Therefore, if it amounts to reduction of capital, company has to ensure that has it followed the procedure to be adopted as prescribed in the Act for reduction of capital. Else, it will be an offense by the company. Now, this is in brief about how share premium. Now let's have a look at the shares issued at a discount. Let's have a look at it. There is a bar on a company on issuing shares at a discount. with an exception. A company shall not issue shares at a discount, means it has to be issued at par or at a premium. However, if the company is issuing sweat equity shares, it is allowed to issue the shares at a discount. We will be seeing separately what is this sweat equity share. And what if a company proceeds and issues shares at a discount? The transaction will be void and any money received by the company has to be refunded with an interest of 12% per annum from the date of issue of such shares. Means the decision of issue doesn't stand the test of law and it has to be refunded and the transaction is void. It doesn't exist. However, sometimes a company in difficulties enters into an arrangement with the creditors, or there may be a restructuring done by financial institutions or banks under the Reserve Bank of India Act. As a part of the scheme of restructuring, it is allowed for a company to issue shares at a discount because it is a matter of accommodation by the creditors. Therefore, this is a special instance where the company can issue shares at a discount. To revisit the whole thing, there is a penalty because anything against this section is an offense and every officer in default shall be, and the penalty is quantified. We have to be more worried about ensuring compliance, being at the same time aware of the penalty which is attracted. To put it once again, issue not allowed except when it is sweat equity shares. Any transaction which is done is void when you make a composition with the creditors or there is a scheme of restructuring done by the banks. It is allowed. If you don't follow the rules as specified in section 53, you will be attracting penalty. Now that is about the share premium account and issue of shares at a discount. Now let us come to the third aspect of this topic as to further issue of capital. A company is already running with the equity shareholders and existing structure. It wants to issue new set of shares that will be covered under fresh issue of capital. Let us understand the further issue of share capital. If we look at it, section 62 says when you make a fresh issue of shares, you have an option to offer such shares to three entities. First one is you can offer it to persons who are holders of equity shares of the company as on the date of offer, or you can issue to employees under a scheme of employee stock option which is separately authorized under a special resolution, or you can offer it to any person under a prospectus which is authorized by a special resolution. Therefore, further issue could be to three entities, 1, 2 and 3. The other two we will be seeing employee stock option separately, and anything which is issued to outsiders by way of a special resolution after sticking to the requirements of issue of prospectus under chapter 3, it is also respected. But the first part of it, which is to people who are holders of equity as on date, the Act prescribes a procedure for that. It says the company should make a letter of offer, and the letter of offer should be sent to the existing shareholders, and they should be given 15 days time to either accept the offer or decline the offer. How do you reach these letters of offer to these people? It could be sent by electronic mode, by registered post, or by speed post, but ensure that you get an acknowledgement, and it has to reach them at least 3 days before the issue opens, and once issue opens they have got 15 days. And this is called a rights offer. This offer will also be accompanied by a renouncement part of it. The existing shareholder can accept the shares fully, he can reject the shares fully, or he can accept partially and renounce partially in favor of a third person. The party who is an outsider, he can take the renouncement application and he can apply to the company making payment as per the terms. And this renouncement can be either full or partial. For example, if the party receives an offer for 100, he can accept full 100, or he can renounce full 100, or he can accept 10 and he can renounce 90. And that renouncement application has to be filed within the specific date of offer. If the shareholder declines, the ball gets into the court of the board. Board can dispose of those shares in a way it considers in the interest of both shareholders and the company. Means, to go by the wording of the act, it should not be disadvantageous to both shareholder as well as the company. This is how the first set of offer will be dealt with. Second set is pertaining to the offer made to employee stock option. Third one is an offer which could be made under a regular prospectus for cash or for consideration other than cash, complying with the requirement of Chapter 3. And sometimes these rights issue, it says you cannot issue shares to others, but there is an exception. A company must have taken a loan or issued debentures. When it takes a loan or takes a debenture, there might be a clause in that debenture or the loan that in the event of non-payment or in terms of this issue, these debentures or loan will be converted into equity. This is an agreement which is already done. When that loan was taken, when that debenture was issued, there must have been passed a special resolution by the company consenting that we have no issue in granting additional shares to these people when we convert the debentures into shares or loan into shares. Therefore, the rule that further issue should be to only shareholders, not anyone else, has got an exception in this. This is increase of subscribed capital caused by exercise of an option by a term attached to debentures or loan which were approved in the past. And any rule that is there, any privilege that is there, it is always subject to any extra steps taken by the government. Notwithstanding what is stated in this section on further issue of capital, it is up to the government in public interest to direct that some loans or debentures be converted into shares, and they should be accordingly documented with the company, including changing the respective sources of power like memorandum and articles which empower the company to issue the same. This is an exceptional case of government intervention in public interest. For example, if the government has given a loan to the company and the company has defaulted, there was no clause in the original issue that it can be converted into equity. Government can step in and as a part of public interest and protecting the interest of existing shareholders and the company, it can state that we can convert that and add it to the existing shares, and further issue of shares could be done. And when such things are done by the government, once again, any decision which affects your right, you have got a remedy, and you can always approach the tribunal from the company against the decision of the court, decision of the government, and await their decision after hearing the company and the government. And whenever the government converts existing loan or debentures into equity, it will have taking care of the financial position while deciding on what should be the term of conversion and what should be the rate of interest payable on the debentures or loan, and other terms as it considers necessary. And as we said, if the company moves the tribunal against the order of the government, and if the appeal has been dismissed, then company is bound to implement the decision of the government to issue further shares in conversion, and automatically the share capital in various documents of the company stand increased to the extent of the new issue approved by the state government. Suffice to say, this whole issue talks of further issue of share capital can be done to only existing shareholders, absolutely no right, no problem. But the point is, if there is an existing debenture or loan raised with a condition of conversion, that prevails. Second, government also can step in and order for conversion of certain loans or assistance given to the company on terms it finds essential, keeping in mind the financial status of the company. The company has got the right to move the tribunal as an appeal. If the appeal is dismissed by the court, company has got the duty to implement the decision of the government, including changing the articles and giving effect to the transaction in all its aspects. That is regarding the further issue of capital. This brings us to a topic called sweat equity. Sweat equity was an issue of interest in case of IPL also. I think it was in 2010, Kochi Tuskers had payment of consideration to one of the parties as sweat equity, but it did not conform to the norms, and therefore the whole scandal broke out. That is history. Let us get into sweat equity as a part of it. What is sweat equity? In section 53, we said any further issue of capital has to be for the existing shareholders. But section 54 gives an exception. It says, notwithstanding anything contained in section 53, means this is an exception to section 53. A company can issue sweat equity shares of a class of shares already issued. Class of shares is already there, but it has to follow three conditions. It should be by a special resolution of the company. Number one, it should specify the number of shares, what is the consideration for which it is issued, and it can be issued to two sets of people. The people who receive sweat equity has to be either directors or employees, and where the shares are listed, the issue has to be based on SEBI regulations. Three specific requirements of sweat equity: pass a special resolution, put all details of what is the number of shares, what is the consideration, and ensure it is issued to either a director or an employee. And who is the director employee, we will see. Third, if it is listed, it should be as per SEBI regulations. Okay. Then, such equity shares to its directors or employees, and we saw in case of shares to be issued as discount, it said accepting sweat equity shares. Sweat equity shares could be issued at a discount, means they can be sold at a price lower than their face value for consideration other than cash also. Company need not have to receive cash. Why it is given? It may be given for the know-how, company gets technical know-how, or it might get intellectual property rights, or some value addition somewhere. This is what the company receives as consideration other than cash. They might not be paying you in cash, but they will give you the technical know-how, or they will give you the intellectual property rights, or they may give you some value addition in a process or product or marketing. Who is an employee? We said it should be an employee or director. Employee must be a permanent employee on the regular roles of the company. And who is a director? Is a director of the company, and he can be a director of a subsidiary also, or he can be a director of a holding company also, but he cannot be a nominee director, or he cannot be an independent director. That we have to indicate. And we came out a word called value additions here. Value additions means actual or anticipated economic benefits, some value saving somewhere company receives, or professional for providing technical know-how. And we have to see one thing. An employee is normally paid salary for what he does. But if he has done something which is different from what he is supposed to do in his employment, his salary doesn't cover that. If an employee provides technical know-how, if an employee provides IPR, or if an employee provides value addition besides his normal job, it is not covered by his regular remuneration. It is not included in his regular remuneration. Therefore, he gets his salary, in addition to that, he will receive sweat equity shares. Sweat equity shares have nothing to do with the normal course of work. Sweat equity shares are more concerned with these three things: technical know-how, intellectual property rights, and value additions. Let's go further. And the rights, limitations, restrictions applicable to equity shares equally apply to sweat equity shares. Just because they are given for consideration other than cash, their rights are not affected. If there are existing equity shareholders, we have issued a fresh equity shares as sweat equity shares, they are equal in all respects, ignoring that they have not been issued against cash. Their rights are the same and they rank pari passu. In the sense, if they are in existence for 365 days in a year, they are entitled to all rights which the other class enjoys as equity shareholders. If they are for say 6 months in a year, they will get benefits for 6 months, the rest of the equity will get benefits for 12 months. Just to revisit, it is an exception to section 53. It should be a special resolution. Details should be indicated in terms of consideration and value received. It can be directors or employees. SEBI guidelines to be followed by listed company. It can be for consideration other than cash. It can be for technical know-how or intellectual property rights or value additions. Employee should be a permanent employee. He can be an employee of a subsidiary or holding company of the group. And the value additions are nothing but economic benefits. They are not included in the normal remuneration paid to an employee. So when you issue sweat equity shares, once again, you need to have a special resolution and you will make an explanatory statement. And as we have seen, when you make an explanatory statement, you make a project features list. Which board meeting did discuss this? What was the justification for the issue? What class of shares are issued? Total number of shares? Classes of directors or employees covered? What are the terms and conditions? What is the time period of association of such person with the company? Is he a new employee or how long he has been there? What is his contribution? What is the relationship with the promoters? At what price the shares are issued? What is the consideration? And does it affect the remuneration of managerial, ceiling on managerial remuneration as per the Companies Act? And is it in line with the accounting standards, the way we have treated in the statement of account? And what is its impact on the earning per share once these shares are issued? Means what? When you issue this explanatory statement, your whole idea is to tell the equity holders, this is how your rights will be affected by issue of these shares. How many shares are issued? In what way they are issued? What is the value? How many numbers? To whom? His background? And what is the impact on EPS? How it will be presented as per the accounting standards. Now, this is the summary where the explanatory statement has to appear like. As we have seen, this has to be reflected in terms of certain other additional conditions also. Once you pass a special resolution, it should be implemented within next 12 months. It expires at the end of 12 months. And there is a restriction. A company cannot issue sweat equity shares in an year more than either rupees 5 crores or 15% of existing paid up capital, whichever is high. This is the outer limit for that. And at any point in time, if you take the balance sheet of a company, sweat equity shares in the total capital means shares which are issued for consideration other than cash under this section, they should not be crossing the limit of 25% at any time. These are the two conditions to be ensured. And when you issue shares for consideration other than cash as a sweat equity, there is a lock-in. They can't be sold within next 3 years. And just like a quarantine stamp, the share certificates will be stamped in bold, stating they are locked in. And in records, there will be the record as to at what price the shares are issued, because they are not issued at the regular price. There will be a price for the shares issue based on a registered valuation. Secondly, whatever benefit they have bought, we will be paying for it, and what they have brought has to be valued by a registered valuer. To put it very clearly, there are two things. One, A, there is a technical know-how. What is its value? Its value may be 1 crore. B, we are issuing him shares. What is the price of the shares? Price of the shares normal is 100, but we are giving him at the rate of 80. When you are giving it at 80, two things become very clear. Shares are valued at a price determined by the valuer. Our shares are valued at 80. Second, the property value is valued at 1 crore. This is once again based on the registered valuer. Both should be valued. And then we derive the number of shares. 1 crore divided by rupees 80 is the number of shares to be issued. That is the extent of sweat equity. And a gist of the critical elements of the valuation report which is there also should go along with the explanatory statement. And as we saw, the board of directors report for the year should once again present this summary. It should say during the year we have issued sweat equity shares with the following features, which is nothing but an extract from the explanatory statement which was sent. Therefore, these two documents are mirrors of each other, issued at different points in time. Therefore, for a sweat equity share, besides the explanatory statement, We have got the limitation in terms of it should not exceed 15% of the paid up capital or rupees 5 crore during any year, and at any point in time it should not exceed 25% of the total capital. There is a lock-in, and there should be a registered valuation both for the shares and for the property received, and board of directors report should mention clearly with the same particulars on the transaction of sweat equity shares. That brings us to bonus shares. Under section 63, we have seen share premium could be used for issue of bonus shares. What are the conditions under bonus shares? A company can issue bonus shares by making use of its reserves. Reserves means profits of the past carried forward. It can use the share premium received, and companies have got a practice of creating a capital redemption reserve out of their profits on a regular basis. These three put together could be used for issuing bonus shares to the shareholders. Bonus shares conveys shares issued without any charge to shareholder. He need not have to pay for it. Now, there is one more reserve which normally appears in the balance sheet. People maybe revalue their fixed assets, land, building and others, and show it the corresponding revaluation as an additional reserve on the liability side, which is called revaluation reserve on revaluation of assets. This is a book entry just to reflect reality. This cannot be distributed to shareholders. Therefore, bonus issue cannot make use of any revaluation reserve. Therefore, these three components could be used for rewarding the shareholders with a bonus issue. And bonus issue means what? It converts share premium, capital redemption and free reserves into bonus shares, into share capital, which is nothing but capitalization of profits. Now, to capitalize a profit in a company, there are some conditions to be fulfilled. One, it should be permitted by the articles. Articles should say company is authorized to convert reserves into capital. Second, it should be discussed in the board. There should be a board recommendation. Third, when you convert these things into capital, they become shares. Shares will get rights and dividends. It will affect the rights of other stakeholders. In that case, one has to ensure that there is no default in the payment of interest or principal in respect of deposits and debts. Once again, clean, strong financial companies alone are permitted to go for bonus shares. If you are not servicing your existing creditors or existing stakeholders, you cannot reward your equity holders by converting that into capital, because when you convert or capitalize, your commitment of dividend increases, outflow of dividends in future increases, earning per share comes down because the number of shares gets bloated. And the company should have not defaulted on any statutory dues. And before you issue bonus shares could be issued only on fully paid shares. Therefore, if the existing shares are partly paid, first they should be fully paid up. Only fully paid up shares are eligible for bonus. This has to be done as a part of preparation. And there may be other conditions as may be prescribed by SEBI or stock exchanges which needs to be fulfilled. And when a company issues bonus shares, it cannot be bartered for dividend. Company cannot tell the shareholders, this year we will give you bonus, but we will not give you dividend. It is prohibited. There cannot be a barter between bonus shares and dividend. Dividend is independent of bonus shares, and therefore bonus cannot be issued in lieu of dividend. And second, it is just like dividend. Dividend once declared cannot be cancelled. It has to be paid. Similarly, bonus once declared cannot be withdrawn. Company has to issue the bonus shares. Once announced, shall not be withdrawn. Bonus shares are a simple thing. You capitalize the profits. You capitalize these three things. You cannot capitalize revaluation assets, but you should be a clean company. Article should permit, board should recommend. There should be no default in terms of deposits and debt securities. No defaults of statutory dues. Shares should be fully paid up. And there may be any other conditions. You cannot barter bonus for dividend. And once announced, it is just like a debt. It has to be issued by the company. And a company cannot announce once and then say withdrawn. No, there is no option to withdraw. In this part B video, we have covered securities premium account, shares issued at a discount, further issue of capital, sweat equity, and bonus shares. Please refer part A video for capital and rights and part C video for change in capital, employee stock option, and global deposit receipt. Thank you so much.